and welcome to Amending the Constitution for the nth time. You may have seen previous presentations. Trust me, this is a good one. I know the other ones were good, but this one is even better. Trust me, I have a really good feeling about this. Anyway, so, amending the Constitution. What do you need to know? Well, you need to know three things. You need to know about the mechanics. How do you amend it? You need to know the advantages and disadvantages of this process, and you need to know what that means in the real world. That's it. Okay, those three things. Obviously, if you know the amendments themselves, then that's a good thing. You should have by now worked out that it's a balancing act. We're balancing, on the one hand, necessary fundamental change while trying to prevent elective short-term measures that may in the future need reassessing. And of course there, primarily, we're thinking about the wonderful booze. Right, okay. And again, more evidence that I shouldn't be an art teacher. So, amending the Constitution mechanics. 11,537 have been considered, 33 have been proposed by Congress, only 27 of those have been ratified by the states. Process, two-stage process, okay? It is a two-stage process. Do you need to know that that's 2/3 and that's 3/4, or do you simply need to know that in both instances it requires a supermajority? Well, you have a choice. You can either remember 2/3 and 3/4 or the supermajority. One of those is more impressive than the other. I'll leave you to work out why, or which, sorry. Now, proposed. Most of them have been proposed by Congress, okay? National Constitutional Convention, that has never happened, okay? We've never had that National Constitutional Convention called by 2/3 of the states, although it's kind of close to what happened when the original Bill of Rights were assessed. It needs to be ratified by a different organization, normally 3/4 of state legislatures, or indeed state constitutional conventions. Again, doesn't happen very often. Congress gets to decide which is which. The standard route is this one. Okay, that is the way that most of them tend to go through. Most of the amendments we consider go through thus. Now, it's worth pointing out, I suppose, at this point, that at no point do the people actually get out and vote on an amendment, okay? It is done by our elected representatives as a feature of representative democracy. So those of you who might argue that the amendment process is democratic, well, you're going to be a long time arguing that, and there are more important points to make. Anyway, what do we need to know about this? It is a two-stage process, Congress to the states, and in both occasions it requires a supermajority. Good. Process simple, a mechanical question that you need to explain. Here's our 16th Amendment. Supreme Court decides in Pollock that all those federal laws imposing income taxes are unconstitutional. They had a point. There was nothing in the Constitution that allowed that allowed Congress to levy an income tax. So what did Congress do? They proposed that they amend the Constitution to allow them to levy an income tax. And in 1909, that happened. Congress passed the 16th Amendment by more than this required 66%. That then went to the states for ratification. So again, we have the two-stage process here. Proposal and ratification. And we can see that this whole process took 4 years. So one of the concerns we've got with the amendment process is that anyone looking for a fast and speedy response may find themselves sadly disappointed. A few states rejected the amendment, but of course they are bound by the Constitution. Connecticut, Rhode Island, Utah, and Virginia all said, we do not think this is a good idea, but it was no good. The 75% threshold was passed here in 1913, and the Constitution was amended. So there you go. Two-stage process, evident there. Long process, evident over the time that it took to go through. Now, you'll know my little party trick about the 27 amendments to the 15 amendments. Why doesn't the Bill of Rights count as an amendment? Well, of course they are amendments, but they were attached to the original text after it was drafted, but before it was ratified. So this is all to do with the Massachusetts Compromise in 1788, which reconciled those who thought the state was too powerful with those who thought, we really need to have a strong state. The only way they were going to do that was by imposing strict limits on what the state could and could not do, and it balanced the power of the state with the rights of individuals. I should also point out there that the 10th Amendment specifically deals with the rights of states, and that's a key point in terms of federal, in terms of the balance of federal power. And again, we'll look at that when we come to look at federalism more generally. Very good video that you can look there on the Massachusetts Compromise. These are the Bill of Rights. Now, in terms of the ones you need to know about, this one definitely, this one definitely, this one you don't really need to know that much about. This one is a good one. This one is very, very useful when you're watching procedural cop dramas, but in the course of the course that we're looking at, not really that important. Same with this, same with this. So yeah, they're not particularly important, sorry. Very, very important if you find yourself in court, naturally. But what we are going to be interested in really is that one and that one as well. So the most important ones, the ones we'll be talking about a lot over the course of the course, 1, 2, 8, and 10. There will be others we'll address from time to time, but the better familiar you are with all of these amendments, the better you're going to be going forward. Here's some more significant amendments. Now, all of these are very important for various reasons, obviously, in terms of society, justice, and general humanity. That's quite relevant, as is this one. However, the one that we're going to spend an awful lot of time talking about is this one. And I strongly urge that you look at the Hip Hughes video on it. I know you find him annoying. I'm not entirely disagreeing with that. However, he is brilliant. The stuff that he has in that is really, really, really strong. Then in terms of procedure, this one's interesting, this one's interesting, and this one is interesting. And then in terms of, yeah, I suppose we should sort that. Okay, all right, here I am. That's a good thing, as is that one. But the ones that we're going to be interested in from a technical point of view, these ones and this one, and the one that's going to impose so much interest in the course later, the 14th Amendment. The happier you are with the 14th Amendment, the more you're going to enjoy American politics. Here are those numbers. Oh, 11,539, sorry. That's probably out of date anyway. Anyway, 33 have been proposed by Congress. 27. The 6 that didn't make it through. Do you need to know them? No, not really. But they're out there and you can always chuck those in. Right, let's talk about amending the Constitution. How do we feel about this whole process? Well, good things. First of all, it's a two-stage process, different constituencies. That means that the level of debate has to be rigorous. So rigorous, yeah, I changed my mind. Rigorous debate, there we go. And you can also argue that in this it preserves federal principles because the states essentially have the right of veto over what Congress wants to do. Finally, the process protects against frivolous and ill-considered amendments. You know, one error there in 200 years is actually not bad going. I think that's probably just about as much as you need to say. We spent a long time coming up with the wording of these particular points, and I like that. Frivolous or ill-considered amendments, and certainly banning booze is, well, it's not frivolous, but it is ill-considered. Okay, so that's that. That's the good things. Now let's look at the bad things about the process. First of all, it takes ages, or it can take ages. 16th Amendment, as we saw, took 4 years. Some have been passed within a year, but it is definitely quite a long and tedious process for everyone involved. Perhaps the bigger issue here is consensus is difficult to achieve. The court is geared towards stasis. There is a vested interest in the status quo. It's very, very hard to change the Constitution because it's difficult to achieve consensus. You need, remember, 66% of Congress and, of course, 75% of the states. And it's very, very hard to see how you're going to achieve those one way or the other. Certainly when it gets to emotive things like gay rights and the death penalty. It's going to be hard to see how you're going to achieve the consensus one way or the other. Of course, that is a good thing as much as it's a bad thing. When it comes to gay rights, it's virtually inconceivable that we can think of anyone being able to amend the Constitution one way or the other. So yeah, we're not going to have a constitutional amendment guaranteeing gay rights, but by the same token, it seems very, very unlikely that we're going to have a constitutional amendment prohibiting or refusing to recognize gay rights, certainly any time in the immediate or indeed medium term. So consensus is difficult to achieve, and there we go, that's it, we'll leave it at that. And in the absence of constitutional certainty, you know, what is cruel and unusual? Should gay people have rights? the question defaults to the Supreme Court. The question will get raised through various cases, and it will inevitably end up in the Supreme Court. And that really is where I want to go here. Everything ends in the Supreme Court. Gay rights, flag burning, guns. Is the death penalty cruel and unusual? The Constitution, in some areas, is not clear. In other areas, the Constitution seems to be out of step with wider society, or certainly with some aspects of society. And so where we can't change the Constitution, either granting or banning gay rights, either banning flag burning or allowing flag burning, either getting rid of that pesky Second Amendment, or establishing what is cruel and unusual, that's the Eighth Amendment. I missed that one out of it. You need to know about the Eighth Amendment. Silly me. But I'm not going to do this blinking thing again. I've done it too many times already. So, what is or is not cruel and unusual? All of these areas are hotly contested areas where we could probably do with amending the Constitution. However, you're not going to get consensus. You're not going to be able to get everyone to agree. And so it goes to the Supreme Court. This has a couple of consequences. First of all, it leads to the politicization of the court. Now, as we go on to discuss, if you've got a politically appointed body and then you ask it political questions, politicization is a kind of moot idea. It is evidently a political body, but we try to pretend that the court is not political. However, every time it's asked one of these questions, it gets dragged into the mucky world of politics, and it becomes ever harder to ignore the assertion that the Supreme Court really is just judges, just politicians in disguise, excuse me. Perhaps more of an issue is the idea that judgments vary according to the balance of the courts. And we see with death penalty and gay rights, sometimes the balance of the court will determine the outcome, and that's particularly acute with gay rights. We've had a couple of judgments recently that have advocated gay rights. If we see the balance of the court shift, then it's likely we'll get a different outcome. And obviously some people are really going to suffer for that. I've got campaign funding here. Okay, I accept this is not the raciest of all subjects, but let's have a quick look at it. But before we do that, gay rights. Now, as I said here, these are two landmark cases where the Supreme Court has basically ruled in favor of gay rights. If the Supreme Court were to change a balance, this may change. And we can see that because if we look at case study campaign finance, the McCain-Feingold Act, you'll be doing this an awful lot in Unit 1. This was an attempt to stem money pouring into American politics. So the McCain-Feingold Act, a very well-intentioned legislation designed to stem that flow of cash. Immediately it was challenged in the court. In 2003, in McConnell versus FEC, the court upheld the constitutionality of the Bipartisan Finance Reform Act, the Campaign Finance Reform Act. But then again, it was challenged in 2008, and part of the act was declared unconstitutional. And then in 2010, it was challenged again, and again another bit of the act was dismantled. And then by the time we get to McCutcheon in 2014, there wasn't very much left of the McCain-Feingold Act at all. So the question is then, why is an act that is constitutional in 2003 not constitutional in 2008? What changed to the Constitution between 2003 and 2008? Well, have a think about that, but I'll tell you the answer right now. Nothing changed in the Constitution. What changed was the court. Specifically, O'Connor resigned, and she was replaced by Alito, Samuel Alito. And Alito is very conservative. Sandra Day O'Connor was a swing justice, but she tended to swing liberal rather than conservative. So here we see the way in which the constitutionality of a particular idea will change depending upon who is on the Supreme Court. We'll look at that in much more detail when we look at the Supreme Court itself. There are obviously a few more things to look at in the rest of the presentation. We've kind of covered all of these already, I think, and I am running out of time. But there we go. That is Amending the Constitution. This is hopefully the last presentation I'm ever going to deliver on it. And that's it. I shall see you in class. Take care. Bye now.